Hi, I'm Steve Waller. I'm a labor lawyer with the firm of Nelligan O'Brien Payne, and today I'm going to talk about labor arbitration. Often I'm dealing with people who haven't been to an arbitration before, and they have one question: what can I expect at the arbitration? And the answer is really twofold. First, you can expect a hearing that's somewhat like a trial in court. And second, if you're a witness, you can expect to be asked a lot of questions. And the role of witnesses in the arbitration is key. So it's very important for those who will be witnesses to know what to expect at the arbitration. Now, when I talk about a labor arbitration, I'm talking about what's known as a rights arbitration. A rights arbitration is a hearing in which the arbitrator decides what rights employees, unions, and employers have under their existing collective agreement. I'm not talking today about another kind of labor arbitration called interest arbitration. In an interest arbitration, the arbitrator will decide what your next collective agreement is going to say. So that's a quite different process. Everything I say today is restricted to rights arbitrations. So I said that a labor arbitration is somewhat like a court trial. And we've all seen on TV and in movies court trials. A labor arbitration is similar in many respects. For example, the hearing is conducted by a kind of judge who's called an arbitrator. Sometimes the hearing is conducted by a three-person panel that's called an arbitration board. Another similarity to a trial is this: the labor arbitration hearing has the same phases as a court trial. It starts with preliminary motions, if there are any. Then the parties make opening statements. Then evidence is introduced through filing documents and hearing the testimony of witnesses. And then there's final argument, just as in a trial. And like a judge, a labor arbitrator can make a final and binding decision to settle your dispute. Well then, how does a labor arbitration differ from a trial in court? Well, one major difference is this. In a labor arbitration, it's common for the arbitrator to try to mediate a settlement to the dispute. Trial judges don't do that. And often, the labor arbitrator will try to mediate a settlement right after opening statements. In a mediation arbitration, or med-arb, the parties agree in advance that the arbitrator will first try to mediate a settlement and will only make a decision if mediation does not produce a settlement. Another difference is that arbitration hearings are less formal than trials in court. As but one example, in court, parties are expected to stand at various points, whereas in a labor arbitration, everybody generally makes their presentations and gives their evidence sitting down. My name is Steve Waller, and I'm a labor lawyer with Nelligan O'Brien Payne.